A very warm welcome, a very warm good morning or good afternoon, depending on where you are joining us. I'm delighted to see so many participants already who've joined us. And it's a few minutes past the hour, so I think we're good to start and then hope to catch up anyone who might join in a moment. I'm so excited to have this session specifically on the engagement and involvement of civil society organizations for the International Court of Justice advisory opinion. We have 4 weeks left. The submission deadline is March 22nd, as you will have read in the event description. So 4 big weeks where we can utilize a lot of civil society engagement to really get a lot of states to submit their written submissions or to file their written submissions to the court in The Hague. My name is Jule Schnakenberg. I am with World's Youth for Climate Justice, the youth organization that is working or has been working on the ICJ advisory opinion for several years. I'm based in The Hague and I have the pleasure to moderate the session and let our speakers shine and share their legal and activist experience with you today, all around the question on what we can do in the next 4 weeks. We have a few housekeeping matters. We have an interpretation function at the bottom, so you can select English or Spanish. Feel free to switch and select the language that you feel most comfortable with. This is also a reminder to our speakers to speak slow enough so that the interpreters are able to follow. We have a Q&A function as well at the bottom, so you can ask questions to our panelists. We have about, if I do my job well, about 20 minutes for Q&A in the end. And we have a chat function also, so feel free to introduce yourself. We've had a session this morning where the chat was a great way for synergies to be built for people to network. And without further ado, I'd like to hear from those who started all of this and with whom or without them we really would not be here today. The ICJ advisory opinion started in the Pacific by Pacific Youth, and I'm very, very happy that Vishal Prasad, the campaign director for the Pacific Island Students Fighting Climate Change, was able to record a short video statement on the rationale and the goals of the campaign. Over to the video. Thank you.
It is so great to see Limacher, ladies and gentlemen, it is so great to see this briefing come together to update all interested partners and supporters on where the ICJ AO campaign is and the areas in which we will need your support in. I will begin by briefly highlighting this campaign's origins and rationale and help set the scene for our discussions today. We launched the campaign to seek an advisory opinion from the International Court of Justice to request the court to clarify what states' obligations are in protecting the rights of current and future generations from the adverse effects of climate change. As many of you would know, this campaign began in the classrooms of our regional university by 27 law students determined to contribute a meaningful solution in the fight against the climate crisis, against the backdrop of a global impasse in climate action. We see that the advisory opinion could act as a legal circuit breaker to the political impasse on climate change and will help to catalyze greater climate action by integrating climate law and human rights law, promoting more ambitious action under the Paris Agreement, cementing consensus on the scientific evidence behind climate change, and by providing authoritative baselines for country actions and for adjudications at the national, regional, and international levels. For young people, this campaign is a declaration that we do not wish to stand on the sidelines as the climate crisis ravages our homes and our planet. While it has been progressing, global action on climate change is not moving at a pace that would avert catastrophic danger, and there is a need for an all-hands-on-deck approach to addressing the climate crisis. The recent IPCC report confirms this prediction of an even bleaker future if we do not change course. We do not accept this fate. We choose to retain hope that our countries are resilient and that international law and its institutions remain a global beacon of respect for a just and peaceful international order that can illuminate the path ahead for us. This is why we take on this fight for climate justice and why we intend to seek an advisory opinion from the ICJ. Since the beginning, we have campaigned for an ICJ AO that focuses on human rights and intergenerational equity. And we're delighted to see that the current legal question before the ICJ has a strong focus on this. Why a human rights question? Because human rights obligations provide a legal basis to compel stronger and more rapid action by governments. They highlight the moral high ground we stand on. It is a forward-looking approach that focuses on the future and avoids naming and shaming and is therefore more likely to gather support. And human rights have more radical potential due to being inalienable and not based on the lowest common denominator or political convenience. Negotiations under the UNFCCC framework remain one of the most important tools in addressing the crisis. An advisory opinion can promote more ambitious action under the Paris Agreement. The voluntary nature of the Paris Agreement requires continued encouragement for more ambitious action among states, and the advisory opinion, while complementing the Paris Agreement, can also encourage greater action. In doing so, the advisory opinion would also help set more concrete and authoritative baselines for state action in reducing emissions and meeting their human rights and climate action responsibilities fully. In this way, an ICJ AO would not be an attempt to undermine, but rather complement and bolster global climate negotiations. More broadly, the ICJ advisory opinion would provide and empower civil society organizations and climate activists with a potent tool to combat environmental injustices worldwide. Having the security of a clarified legal position would mean new and stronger forms of action that activists can lead, resulting in protecting the environment and pollution control becoming serious considerations and action points for states. Not only would the ICJ AO be a legal circuit breaker for global negotiations, it would also be a major confidence booster to the work of all climate activists worldwide. Our journey towards climate justice now needs the support of countries to advance strong, robust and ambitious submissions before the ICJ so that the final opinion is informed by this. There will be several lukewarm, much business as usual submissions before the ICJ, and we need to rise above these and seize this opportunity to shape the development of international law to work for our people. This is a generational opportunity, and we need countries to stand on the right side of history and make the most of this opportunity on the 22nd of March so that the next time when we go to a COP meeting or a negotiation meeting, we will be going from a position of strength. The ICJ advisory opinion can help make that happen. Pinaka Vakalevu, and thank you.
Thank you very much, Vishal, who is due to the time difference unable to be here today, but I think in a very comprehensive and passionate way and very convincing way has explained the origin, the rationale, and the goals of the Pacific students and the entire civil society movement for the ICJ advisory opinion. And I am very, very happy that we have another video message by the UN Special Rapporteur on Human Rights and the Environment. Professor David Boyd has shared a short message for all of you, for our audience today, on the importance of the advisory opinion to uphold the human rights of current and future generations. And I thank him very much for sharing this video message with us. And then over to the video. Thank you.
Hello from Canada. I'm Dr. David Boyd, the United Nations Special Rapporteur on Human Rights and the Environment. We have a once-in-a-lifetime opportunity to clarify states' obligations in respect to the climate emergency, drawing upon international environmental law and international human rights law to craft a science and human rights-based approach. But first, I'd like to just quickly acknowledge the leadership of the World Youth for Climate Justice and Vanuatu, with the support of 18 other states as well as other civil society partners, in successfully securing a General Assembly resolution requesting an advisory opinion on state obligations in the context of the climate crisis from the world's highest court, the International Court of Justice. The climate crisis is unequivocally a human rights crisis. Small island developing states, least developed countries, and people in states all across the world who are least responsible for the climate crisis are bearing the heaviest impacts of this crisis. I'm talking about indigenous peoples, people living in poverty, children, older persons, migrants, refugees, and others who find themselves in situations of vulnerability and marginalization. This is a human rights crisis that I have witnessed firsthand in my work as Special Rapporteur. On my first country mission, I went to Fiji, where I visited Vunidogoloa, one of the first communities in the world that had to be completely relocated because of the climate crisis. This oceanfront, beautiful community had to move inland. And so now older persons, persons with disabilities, pregnant women are cut off from the ocean that is their grocery store and the heart of their culture. On my second country mission, I went to Norway and I traveled north of the Arctic Circle to spend time with the indigenous Sami people, for whom reindeer herding is the heart, the beating heart of their culture and their economy. And yet the climate crisis is inflicting incredible problems on reindeer and, by extension, the Sami people. My third country mission was to St. Vincent and the Grenadines, a beautiful island state in the Caribbean. Again, rising sea levels, increasing heat. I spoke to farmers there who said that the heat is just becoming intolerable for working during the day. Then I went to Portugal and spoke to survivors of absolutely terrifying and deadly wildfires made much worse and much more common by the climate crisis. I spoke to pastoralists in Kenya whose livestock, their lifetime savings had been killed by drought. I went to Chile, and Chile is a nation that's in the midst of a multi-decade drought exacerbated by the climate crisis. Most recently, I was in Botswana, where I visited indigenous communities and rural communities that are facing incredible water scarcity, food insecurity, and increasing human-wildlife conflict, all linked to the global climate crisis. In April, I will travel to the Maldives, one of the world's 5 atoll nations. These are nations where the highest point of land is no more than 8 or 10 feet above sea level. So this climate crisis is an existential crisis for the people and the nations such as the Maldives, Kiribati, the Marshall Islands, Tuvalu, and Vanuatu. We have to address this. And unfortunately, the International Court of Justice rejected a request from a group of special rapporteurs to make written submissions on rights-based approaches to the climate crisis because we don't qualify as an international organization. So it's absolutely critical that as many of the states that are being adversely affected by the climate emergency participate in the International Court of Justice advisory opinion process. The deadline is coming up fast for written submissions. It's March the 22nd, but there are many resources available. There are also academic experts, pro bono lawyers, special rapporteurs, and civil society organizations willing to assist in this critically important endeavor. As I said at the outset, this is a once in a lifetime opportunity to have the world's highest court clarify that states must take a human rights-based approach to all climate action, and that this is an obligation for states, not an option. Thank you very much. And I hope to work with many of you in the future.
Thank you also for that message. From the UN Special Rapporteur on Human Rights and the Environment. And it really underscored the importance of this being a human rights issue that really affects every person living in every state, not equally, but affecting a lot of communities around the world. And towards the end, he mentioned the importance of state submissions, because right now it's only states and international organizations that are formally allowed to make submissions to the court. And I'd like to invite, and I'm very grateful you were able to make it, Lucien from Natural Justice. He's the head of the Defending Rights Program and Litigation at Natural Justice, to share some of some reflections on your engagement specifically with African states, and some opportunities for involvement of civil society organizations. We've heard this started in the Pacific. It's now spreading across the world. We need the whole world to be involved. We need climate vulnerable states. We need countries from the global south, from other parts of the world, to make submissions. And you've been working with African states and in trying to engage states and civil society organizations. So, Lucien, over to you, and we're very curious to hear from your experience. Thank you much.
Thank you. Well, good morning, good afternoon, good evening, colleagues and friends, depending where you are in the Western world. I just want to say thanks, of course, to the organizer of this virtual briefing on the ICJ, for giving me the opportunity to provide some thoughts and reflections regarding the engagement of African states at the ICJ advisory opinion process, as well as the important role that the African CSOs can play in this particular advisory opinion. But however, before we get there, I think it is important to set some context. So, and I think it's really important to just have a quick highlight of the historical relationship between the ICJ and the African states. So as everyone knows, the creation of the ICJ was meant to be an international court that promoted justice and fairness in international disputes between states. However, the participation of African states in the court's proceedings has been relatively limited. And this is primarily because of three reasons. Some involve a lack of financial resources and general awareness of the court proceedings. Others are linked to a distrust of international institutions among some African leaders. And of course, the implementation of having these court orders, if they are in favor with an African state, to be implemented because of political interference. So taking the above context into consideration, the IGA has, although despite what I said before, a crucial institution resolving disputes between states and providing advisory opinions on legal issues which influence international law. With respect to Africa, though, specifically, the court has been engaged in questions on land boundaries, armed conflict between African states. If you want to have a look, we'll be sharing a link through our moderator. There's been a couple of cases, Congo versus Uganda, Kenya versus Somalia, but unfortunately, there hasn't been that many cases. Despite these challenges, though, the ICJ has increasingly become a forum for African states to seek legal recourse on matters of global significance. For example, the recent urgent interdict case between South Africa and Israel is a clear example of that. The climate crisis is also a global issue. And as we all know, Africa suffers more climatic shocks than any other jurisdiction, yet it contributes least to the climate change. And this disparity underscores the urgency of African states to engage with the advisory process and seek legal remedies to address the devastating impacts on climate change on the continent's populations. In the last, I think it was 5 or 6 years, there's been more disasters on the African state than there has ever been before. David Boyd had made some references around devastating droughts. There have also been devastating floods. And because of how Africa has been positioned, a lot of these would impact the socioeconomic rights on the African continent. And I think it's critical that that becomes a highlight story for the African continent when we want to discuss climate change and the impact it has. In January this year, though, the Environmental Lawyers Collective of Africa, partnering with Natural Justice and a number of other key organizations across Africa, we had put a draft letter together which could be used by any CSOs and lawyers in different African jurisdictions to effectively take their government to task about their participation in the advisory process and to request them to include strong positions from the protection of the environment in a manner that benefits future generations, for the inclusion of opinions of affected and vulnerable communities in their submission, and to tackle the issue of loss and damage, as well as mitigation and adaptation. What we have seen from this campaign that we've started is that we were able to reach 15 African countries in the last couple of weeks. Of these, unfortunately, only 2 countries have really started to engage with us whether they were going to make submissions. And only 1 country out of those 2 have actually said they will be making submissions. And those two countries are South Africa and Mozambique will be making submissions to the ICJ. So it's really great that at least we have one country that is going to be making submissions. Not to say that there are other countries who might be making submissions, but unfortunately it's not information that we have because of the fact that there's limited resources to try and connect with 54 countries on the African continent. It's ALCA's hope, or the Environmental Lawyers Collective Association, and Natural Justice, that we can continue to encourage their participation in the process. I mean, we've encountered several problems in our engagements with these states. The couple we've had is political will, or the main one is political will. We've really struggled to try and get sort of engagement with the people within the various ministries. And that, I think, is just because of the fact that there's so much other work happening on the African continent that this is something they haven't really thought about undertaking. Bearing in mind that there are, as I said, 54 countries and especially vulnerable, our hope today is to galvanize the CSOs in this discussion to work with us to place pressure on our governments to recognize their responsibility and to participate in this international dialogue on climate justice. My colleague, Noma Songa, sent through links to our draft letter and annexure. She'll make, in the previous webinar, she will make that available again for this webinar, which can be amended and adapted for any CSO and sent independently. Natural Justice and ALCA just want to make sure that our governments know and are aware that submissions can be made and that they should be making submissions on behalf of the African continent. ALCA and Natural Justice firmly believe that civil society organizations are playing a crucial role, but we just need to get further push with the governments on the African continent to really start pushing this. What we hope to seek today is, we want to really start raising awareness about the importance of engaging on the ICJ and climate change issues. That change can only be done through advocacy campaigns, workshops, and seminars. So thank you again for organizing this seminar. We also wanted to talk about galvanizers to have some monitoring and evaluation. One of the hardest things that's been is, of course, having a couple of partners like ALCA, Natural Justice, and a few others. It's very difficult to monitor and evaluate what is actually happening on the African continent. So although we're continuously engaging with those various organizations, when we have 5 or 6 or 7 organizations, it's difficult to monitor what's happening in 54 countries. So to close, whilst advisory opinions do not have binding authority, they can have persuasive authority about the content of international and may inspire other judges to use these judgments and expand the jurisprudence on responsibility and obligation on states to prevent any further harm from climate change and to make sure that we effectively manage the human rights crises that are currently being occurring on the African continent due to the fact that climate change is having such a massive impact. The engagement of African states in the ICJ advisory opinion process on climate change is crucial for addressing the disproportionate impacts on climate change on the continent and holding the global north accountable, which I think is really key in this point. Africa is the least polluting country across the globe, yet we are one of the most impacted, and we need to hold those responsible and to make sure they undertake the actions that are needed to make sure that Africa can be protected and has a sustainable area for them to live in. Together, I think we can work towards a more just and sustainable future for all. And I'm really looking forward to hear from civil organizations from African continent to see if we can connect with them to really drive home this last month and make sure that our governments make submissions. Thank you.
Thank you so much for taking us through some of the context and the background of the engagement between the International Court of Justice with African countries, some of the challenges you've encountered with your engagement, and the very clear call to action. So any representative from an African civil society organization, please reach out to Natural Justice and you are very much invited. They've prepared some templates, and thank you for the work that you are doing. You said, of course, 54 countries is a massive challenge, but we have so many attendees today, so I'm optimistic and hopeful that some of those attending also the morning session will be reaching out and using some of the resources you have produced in the next 4 weeks. And thank you also for mentioning, and your colleague this morning also very beautifully said, states have the duty and the responsibility to make submissions on behalf of their people. And the whole idea of people in the courtroom, bringing people to the court, and not just having this be a state-led process has been very important from the very beginning for those advocating in the Pacific, really working with local grassroots communities so that everyone really feels like they are part of the court of this process, that this can really be a people's court. And I am very, very happy that Cata Alonso was able to join us today to speak on the perspective. And I saw she just dropped off the call. I just continue with the introduction and then hope she will be able to join us in a second again. She's a human rights defender working, and she's been doing this for 18 years already. For an organization which I will share in the chat. I don't want to butcher the name with my poor Spanish, but here to speak on the lived experience and the importance of being able to be heard in an international court and the importance of that. Do we know if Kata has issues joining us again? All right. I see there's connection issues. Okay, I am happy to come back to that. Then, Joy, if you thought you had some more time to prepare, that time is up. I would be, I'm very happy to move on to Joey, who's with the Center for International Environmental Law and a senior attorney with the Center for International Environmental Law, who's one of the co-sponsors of today's event. And thank you for all the wonderful tech support that the team has provided. Joy, you've been working on the advisory opinion, not just before the ICJ, but also at the International Tribunal for the Law of the Sea and the Inter-American Court, trying, just to rally state engagement, build awareness. And I'd like to ask you if you could share with us the state of play in this process. And we've just had a call to action from Lucien. If you can let our audience know what are some of the short-term opportunities for engagement over the next 4 weeks. Thank you.
Thanks a lot, Jule. And I really hope Kata can rejoin us because I was very much looking forward to hearing her perspective. So just to jump in, zooming out, as Jule said, there's the ICJ advisory opinion, but there's actually 3 ongoing different advisory opinion processes before the International Tribunal for the Law of the Sea, the Inter-American Court of Human Rights, and the International Court of Justice. And these together represent a once-in-a-generation opportunity for international judicial bodies to clarify the obligations of states under international law with respect to climate change. At a time of pervasive, and we've heard, David Boyd talked about this, Lucien talked about this, there is absolutely pervasive climate devastation that we're seeing. Climate negotiations are not delivering. The ICJ process is a complementary process that can bring some clarity on states' legal obligations. The advisory opinions together could make clear that under international law, states must take all appropriate human rights-based actions to urgently phase out fossil fuels equitably, align climate mitigation ambition with science, adopt effective adaptation measures, and provide remedies and reparations for impacted communities, and that governments cannot hide behind the deficiencies of the Paris Agreement. I did see a question on the chat about how traditional the jurisprudence of the ICJ tends to be. So this would be an ideal case scenario, but we do have to keep in mind that while we hope for a very strong and progressive opinion, we must really make sure that we have powerful state submissions in to ensure that strong progressive opinion, because the court's jurisprudence can be quite conservative at times. So we'll focus today more on the ICJ state of play in the ICJ process. Around 50 countries have confirmed so far that they will be making submissions, and this number continues to grow. Several international organizations have also been granted leave to intervene, including, and just for example, the Commission of Small Island States on Climate Change and International Law, and the International Union for Conservation of Nature, IUCN. And interestingly, the Organization of the Petroleum Exporting Countries, OPEC. It is important to pay attention to this. Across the world, climate justice-focused countries and organizations are engaging and mobilizing, but so is the other side. Civil society has really mobilized, as we've heard, and with incredible results, and are also planning submissions, which will not formally be on the record as per the procedural rules, but can still be made to the court and consulted by judges and states. As has been already mentioned by a few of the speakers, the initial written input to the ICJ, the deadline is fast approaching. It is the 22nd of March. And then there will be a second round in the written proceedings where states will be able to see each other's submissions and provide written replies and comments. And the deadline for this is the 24th of June. It is important to emphasize that only states and organizations which have filed a written statement may submit written comments in the second stage. It is thus critical to get a submission in by the 22nd of March, however short, to reserve the right to engage in the second stage of the written proceedings. We're expecting public hearings late 2024 or early next year. Importantly, states or organizations which have not taken part in the written proceedings may take part in the oral proceedings. Time allocated for each oral intervention will likely be quite short, given the expected number of submissions. Two last things to note in the state of play is we have heard, and I think Jule mentioned this, that judges of the ICJ are interested in hearing, as feasible, from directly affected communities. It makes a significant difference when judges hear from perspectives rooted in lived experience. States can incorporate, append community testimony to their written submissions or include community statements and representatives in their oral interventions. And it is good as civil society to encourage them to do so. This process is about legal norms, yes, but also about people's lives and livelihoods, about rights and justice. Also, if you're encouraging a state to engage, and I think Lucien mentioned that many states, they have limited resources. If they are engaging, there are resources available. There is a whole ecosystem of support that exists. There is concrete support from the Vanuatu team. There's been pro bono law firms, academics, civil society lawyers that are supporting states with submissions and providing legal resources. And there have been regional workshops organized for states. So that support does exist. So what can you do in the short term? You can reach out to your state, especially in the global south. I'm using this as shorthand. And if they're not already planning a submission, encourage them to do so. The World's Youth for Climate Justice has outreach materials ready and would be willing to share templates. I'm sure Jule can put in contact information. Lucien has offered to share templates as well for those organizations based in Africa. Please do reach out to them. This is a really critical window to make sure that your state is engaging with this process. If you work with communities and there would be a possibility to send community testimony to your state to incorporate in their submissions and materials, this could be an avenue to explore with your relevant state officials. Narrative building and mobilization. Keep in mind that law and cases have challenges. They're often not very well adhered to. It is important to allow for strategic mobilization towards shaping the narrative around climate change and building political power. Follow proceedings, join mobilization efforts that are being planned by campaigners across spaces. The Pacific Island Students Fighting Climate Change, World's Youth for Climate Justice are planning mobilizations efforts to continue to push key climate justice messages that are being raised in legal submissions, but outwardly facing, in public facing narratives. And then as a last point, and I'll end here, non-legal organizations really have a key role to play in the here and now. The mobilization of Pacific youth and all others rallying behind them has delivered an amazing breakthrough, but we know that the opposition is mobilizing and could really undermine this process. So we need constructive voices to come out clear and loud. It will be important for the court to feel that people across the world are watching and expecting the court to deliver a judgment that not just focuses on black letter law, but uplifts rights and justice. So I'll stop here. Thanks a lot. And I'll hand it back to you, Jule.
Thank you. Very much, and I saw a message in the chat to slow down, so I also take that on myself, and just ask the panelists that if they do respond, or when they respond, that they slow down so that it is a bit easier for the interpreters. Thank you, Joy, for taking us through the importance of community perspectives in the written and in the oral and the commons phase of the process, mentioning the sources of support that have been offered to states, and that civil society organizations, academia, the legal team is willing to continue offering for the next 4 weeks, the importance of narrative building. And this is a reminder, again, there's a Q&A box at the bottom of the Zoom screen. Please do share questions that you have for our panelists in whatever language you're most comfortable with. And there is a question, Vishal mentioned this in the beginning, and both our panelists touched upon it, but a question that ask on what concrete legal consequences might the ICJ advisory opinion deliver? What could be a best case scenario? Vishal mentioned it briefly in the beginning, but if you could outline again, and maybe Lucien, if you're okay to start, what could be some of these consequences the outcomes that we're hoping for, so that this is not just, an exercise that we undertake?
Yeah, I mean that's a great question. I think it's two-pronged. I think one is if we had to have the ultimate outcome that we wanted, is that it's founded in human rights. So any action that's taken is based under human rights, and then we hold the states accountable for undertaking any of those actions. I think if we don't have that basis in this, and it just becomes a letter of the law type judgment where we repeat what the Paris Agreement says and we don't try and expand on that, I think it'd be very difficult to have any momentum. Although it would be still great to have that, it would be very difficult to have any further momentum, because then we're putting it back on the states rather than having a piece of document that says you need to go above and beyond because of this crisis. I think the second one as well is it becomes a tool for advocacy. If we are able to get a court, an international court of justice, to write an advisory opinion that provides some working basis for organizations, CSOs, non-profit organizations to use that and take it back to their government and start holding them accountable and using that jurisprudence to the judges on the African continent or elsewhere, I think as well it becomes incredibly powerful, because you've got the best of the best essentially in the world who are looking at this and applying this case, and you can then take that jurisprudence and apply it back in your own country.
Thank you very much. Joy, is there anything that you think we've not yet mentioned on the potential? What are some of the concrete outcomes of an advisory opinion?
Sure. No, I agree very much with Lucien that human rights law, if the court actually came out and said that one of the biggest legal issues will be concurrent duties, where there are states arguing that state obligations in relation to climate change are really confined to Paris and the UNFCCC. But Paris and the UNFCCC, while very relevant, do not exclusively or exhaustively answer the questions posed before the court. There are long-standing duties under customary international law, under human rights law, and international environmental law. And if the court clarifies that, that would be really important. Also, it would be really interesting for the court to make a pronouncement on fossil fuels, given the legal debates and court battles that we are seeing now. But there's a lot more, but I'll stop here.
If you allow, Joy, staying on fossil fuels, there's a question by Arturo Romano asking, could we consider OPEC's participation as an opportunity for this organization, and therefore the country that they represent, to develop their own arguments in their favor? The question relates to good faith intervention rather than an attempt to limit the court's arguments. So kind of risk that you see around OPEC's participation, risk or chances, if you do see any. Thank you.
I'm not sure that we will see very constructive arguments from OPEC. I mean, it will always be fantastic to see if that did happen. I do think that there might be arguments very strongly about, about legal duties that are not going to constrain fossil fuel use. But I think that's fine because we are expecting those arguments from states as well. And that is why it is really important that progressive states come in and talk about how legal duties require ending reliance on fossil fuels. And for that, states also need to be supported, and things like climate finance become really important. So absolutely, we are expecting problematic arguments from OPEC and from certain states, and we need to counter that. We need to counter that through progressive submissions by states.
Lucien, did you want to jump in on this as well?
Yeah, I just wanted to say one interesting fact from the African continent is that the African Union has been allowed to join as well. So that might be a potential avenue to have the counter narrative against OPEC, because as I said, Africa is one of the most impacted continents on in the world when it comes to CO2 emissions and pollution. And then the other, to be honest, I also agree. I don't think they would be providing anything further. And as Joy said, you've got fossil fuel countries that are very much in line with promoting fossil fuels. But I think it does provide an opportunity to also, from a campaign perspective, hold OPEC accountable, because they're going to be making submissions that we could potentially use as an advocacy tool moving forward. And if there is something constructive in those pleadings, although I'm not sure that's going to be the case, but if there is, we could potentially use that as well.
Thank you very much. Someone a few months ago said to me, maybe it is a good thing that there is a lot of participation. It shows organizations and countries are scared. That's one opinion. I think we're all very eager to see what they have to say. There was 2 questions in the chat relating to whether it's possible to read submissions. I know, Joe, you mentioned that 50 states have indicated they'd be making submissions. Could you speak on how or if at all people could read those already? You're still on mute, sorry.
I'm sorry. For the broader public, no, because the state submissions will be made, and then they will be shared with other intervening states and international organizations. They will not be made public. The point at which they may be made public at the discretion of the president of the court is either at or after the public hearings that will be scheduled. So if a state directly shares it, then it would be possible, but the actual process is confidential. But after the decision is made, then there will be, I think, online different state submissions put on. But yeah, and at the point of the hearing, but before the hearing, it's not possible to see the submissions as public.
Thank you very much. So we do have to be a bit patient unless states are willing to share those with the broader public. I do think also for World Series for Climate Justice, we have done some work on speaking to states and asking them why this is not a transparent process. Are they willing to engage with civil society organizations on the submission that they're making on behalf of their people? So I think it's still a very fair ask, and that has always been included in the letters that we have written to state representatives. There was a question on how to receive the templates, and I believe the CIEL team is going to send a follow-up email, so we can include that in there. I have a question, Lucien or Joy, whoever feels more comfortable answering that. There's a question that there's only 4 weeks left until the submission deadline. Do you foresee a risk that state representatives arguing that there is simply not enough time? And what do you think could be, what would you advise could be an argument to counter that?
Happy to take this. Joy, please go ahead.
Lucien, go ahead.
I think, as Joy mentioned, if you don't make a submission in the first round, you're going to be barred from being part of this process. So even if the submission is literally saying, I want to participate in this process, I know that's, very basic, but obviously it won't be as short as that. It will then give you the opportunity to respond, because although let's say some countries from Africa can't respond because of the short time frame, but they make a submission saying they want to be part of the process, and then the global north comes out with papers that are completely out of left field that go against everything that the African states believe in, then they have an opportunity to reply to the first submission. So I think that is really key. So although there is only 4 weeks, yes, you might not have a robust papers to be submitted, but the cost of not submitting, I would think, would be far worse.
Thank you very much for that response. And Lucien, the question was if you could share your contact information again on how to connect. If you could just put that in the chat again, please. And Lucien, if you allow me, one of the earlier questions, and it was written in Spanish, so I've used DeepL, so I hope I'm not butchering the essence of the question, but this was on state obligations. And Joy had mentioned earlier the court tend to be a bit conservative. And the question asked, couldn't an advisory opinion expressing a very restrictive conception of the obligations of states with respect to climate change end up being counterproductive? And the reason I'm throwing it back to you is because you mentioned earlier that the court and the judges really need to go beyond Paris, beyond the Paris Agreement. Could you answer that question? If it was a very restrictive opinion, could not be counterproductive. Thank you.
Absolutely. I mean, it could be counterintuitive, but that wouldn't stop us from litigating in other forums as well and promoting cases at that level. So, on the African continent, you've got the East African Court of Justice, you've got the ECOWAS Court of Justice, you've got the African Court on Human and People's Rights. So there's many other forums, and I think, Joy, you had mentioned 2 others as well, where you could potentially also go and litigate in those areas if this case is not successful. But so I mean, it won't be an easy task, obviously, because you've got an international judgment that obviously is now very restrictive, but there are other forums for you to potentially pursue and take on cases. Also on the African continent, if you're going to be litigating nationally, depending on the jurisdiction that you're at, sometimes judges will take into consideration, sometimes they won't take into consideration international judgments. But that being said, if we have a judgment that is progressive, you will have a huge advocacy campaign behind backing it. And, judges, I know, are creatures of court, but the reality is they're also human beings. And when they start seeing the advocacy campaigns that come with a positive outcome like the ICJ, I think will have a huge impact on their ability to make judgments and use those cases. But if it becomes restricted, there are ways to negate that impact, but obviously it'll be a complete loss. I mean, it will be a huge blow if that's how the court comes with a very restrictive judgment. Thanks.
If I could come in for a minute as well, and I very much agree with what Lucien said. 2 points to quickly highlight. That this, yes, there is the possibility always that it will be a more restrictive decision, and that's why it's really important to get progressive states to be making strong arguments. But this is not happening in a silo. It's also happening with the ICJ decision and the Inter-American Court advisory opinion processes. And there is understanding from kind of talking to courts, these 3 tribunals, that they are looking at each other's. They are going to be looking at each other's and not trying to create a situation where there will be a lack of coherence in international law. So I do think that hopefully if we get a strong decision, for example, from the Inter-American Court of Human Rights, that this might have a positive impact of the direction of the decision. And then the last thing I'll mention, this point is really important to pay attention to in climate litigation. If there is a decision that is not very strong or could be quite restrictive, that is why it is so important, not just for the lawyers, but also for the campaigners to be involved, because we have seen this. We have seen losses in courts being translated through effective mobilizations into legislative wins, right? Because the public believes that this is where the direction should go. So absolutely kind of keeping the positive key messages, not just in legal submissions, but continuing to talk about it, continuing to mobilize, continuing to really press that internationally, this is where the direction needs to be. That will make a huge difference in how we are able to negate any potentially restrictive decision.
Thank you very much also for emphasizing the need for positive key messages. And I think we have time for one more question before the closing remarks. And that is a question that came not through the Q&A, but through the chat. And that was on connecting CEDAW, so the convention, the elimination of discrimination against women. That is also mentioned in the resolution that the General Assembly passed to even request the court to deliver this advisory opinion. I believe both of you touched upon it earlier, but Joy, if you would be able to come back on maybe the importance or the opportunity that the advisory opinion can also give for human rights, kind of human rights work, human rights defenders, and other issues, since, as David Boyd said, human rights and climate change are so very much interconnected. Thank you.
Sure, very quickly. So the question is how CEDAW's work can be used for the ICJ process. So one thing to note is that the ICJ has referenced in past case law, general comments, for example, even treaty body communications and views. So it is very likely that they will draw on, or they could, there is precedence for doing that. CEDAW has made some very strong, has done some very strong analytical work on climate change and intersectional impact. So we have talked a lot about, and we know as a movement that climate change has these disproportionate impacts on specific populations, more marginalized populations, and CEDAW has really uplifted this. I think it's General Comment 37, on kind of the connection between CEDAW's mandate on women and girls and climate change, and really talks about the issue of intersectionality and what does it mean from a legal lens. And I think this would be really important to highlight before the ICJ, given the fact that an intersectional lens is critical to climate justice.
Thank you very much, Joy. And now with 2 minutes to go, and I've asked Joy already wants to do this today. There's a question in the Q&A, and I think I'd like to ask that as a prompt for the closing remarks. And the question says, how can individuals from academia and civil society organizations push this process forward? So your final call to action, and Lucien, I'd like to start with you, if that's okay.
Of course, thanks. So I think the best way is to get in contact with nonprofit organizations that have already started the campaigns and the advocacy activities, because they will be best positioned to provide you with that support. As Joy and other colleagues have said, you can connect online. I'm sure if you just have to type it into Google, how do I find CIEL, or how do I find natural justice, or how do I find ALCA? They're all available online to connect with people who are interested in taking forward. From the academia side, I think it's critical that academia play a really special role, I think, in countries. They have really close connections with government, depending on the type of work that they're doing. And I think using those channels and connecting with people at government level, saying we need to make sure we make submissions, I think is really critical from the academia side. I know they're supposed to be deemed neutral, but this, as David Boyd said, is a once in a lifetime opportunity. And if we don't get everybody involved now, we're going to have judgment. We're going to have a judgment that we're not happy with. And I think it'll be such a missed opportunity. Thank you.
Thank you very much, Lucien. And same question to you, Joy. What can individuals from academia and civil society do to push the process forward? And you're muted again.
We're doing that a lot today. Sorry, Jule. So I'm realizing we're at time, so very quickly. I think the legal aspect is really important. Reaching out to your states, making sure that there's progressive engagement with this process will be absolutely critical in ensuring a strong outcome. But those of us who litigate know that what happens inside courts does not translate in the longer term to advancing systemic change unless civil society is engaged, is monitoring, taking it forward, insisting on adherence. So civil society engagement is absolutely critical to the successful outcomes of this process. So I really hope that you all stay engaged and work with us towards ensuring very strong outcomes from the ICJ process.
Thank you very much to both of you for staying within your allotted 60 seconds. And we do have to end this already, but just a huge thank you again to those who co-sponsored today. And that was the Climate Action Network, the Pacific Island Students Fighting Climate Change, the Center for International Environmental Law, World's Youth for Climate Justice, and AIDA and Natural Justice. So thanks to that alliance and all those who've supported the campaign over the years. And we hope to, kind of build on the conversation we've had today, share the templates with you, and then coordinate and attack in the most peaceful and in a fierce way. And I think that takes us to the end of the hour, and a big thanks to our interpreters as well for doing an excellent job despite us talking very fast. Thank you very much and have a good rest of the day.